Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Each month, I'll provide an update on the latest developments that matter to you, and we'll be joined by an expert to take a deep dive into a key corporate law topic. Hi everyone, in this episode I'm going to focus on recent developments in two different areas. So in a bit we will have a look at how restructuring plans are being used to help companies in financial difficulties. But first up, we're going to have a look at what's been happening with the regime for national security and investment. So this is the new regime that came in at the start of this year under the National Security Investment Act. And what it does, it allows the government to intervene in a transaction on the basis that that transaction poses a risk to the UK's national security. So, like I say, it came in earlier this year, and we're already beginning to see it have an impact on transaction processes and timetables. But there was some recent guidance from the Department for Business, Energy and Industrial Strategy base, which sheds some light on the types of transactions, the types of events that can be caught by the regime. And I thought it was worth mentioning because it highlights actually the breadth and extent of the regime, and that perhaps transactions that you might not expect to be caught are actually caught by this regime. So it's not just about acquisitions of shares, which is probably what we all think about. Um, Clearly, acquiring control of a company where that company is operating in a sensitive sector, that could be relevant and of concern to the government. But actually, these market guidance notes from BAIS show that there are lots of different events that could actually trigger a requirement to make a mandatory or a voluntary notification under the national security regime. So, for example, acquiring indirect control of a target. So, let's say an acquirer acquires control of say 51% of the shares in a topco, and that topco in turn holds 51% of the shares in a subsidiary company, and that subsidiary company is an entity operating in a specified sector. Well, by acquiring a majority stake in the top company, the buyer will have acquired indirect control of that subsidiary company, and because it's operating in a sensitive sector, that could trigger a requirement for a mandatory notification under the national security regime if the other relevant tests are met. Now, you might think, okay, you can understand that one because ultimately the acquirer is a new company coming in and acquiring control, albeit indirectly, of a sensitive target. But even if there's no change in the entity's ultimate beneficial owners, then a transaction that's sort of maybe part of a group reorganisation could be caught by the regime. So if you imagine in this case, let's say we've got a company A, that's operating in a sensitive sector, so it's an entity of interest under the NSI regime. That company A has a group of shareholders. For whatever reason, that group of shareholders decide to exchange their shares in that company A for shares in a new holding company. So company A becomes a subsidiary of the holding company, and the shareholders become the shareholders in that holding company. So there's no change in the ultimate beneficial owners of that company A, but because there has been a change in its direct ownership, then again a mandatory notification could be required. Like I say, even though there's no change in ultimate beneficial owners. Similarly, even the appointment of a liquidator or a receiver. Generally, rights held by an administrator or creditors are ignored under the NSI regime, but actually, these new guidance notes explain that on the winding up of an entity by a liquidator or the enforcement of secured assets by a receiver, well, those are activities that, again, in some circumstances, could give rise to national security risks. So, if the liquidated entity, the liquidated company, holds shares in a solvent company which is operating in one of the 17 specified sectors under the regime, then again the liquidator or receiver is going to be controlling the voting rights attached to the shares in that subsidiary company. And again, that could trigger a requirement for a mandatory notification. Um, Helpfully, one thing that the guidance has done is confirm that when you're talking about the acquisition of voting rights, because that's one of the normal triggering events under the NSI regime if you're acquiring more than 25% of the shares or voting rights in an entity, then these guidance notes have confirmed that when we're talking about voting rights, what we mean is voting rights attached to shares, and it's only those voting rights that are relevant. So that's going to be particularly welcome news for investors, because the sort of contractual rights which investors might get in an investment or shareholders agreement, allowing them to protect their minority interest, they're not generally going to trigger a requirement for a mandatory notification under the regime. But if those contractual rights do give the investor the ability to materially influence the policy of an entity, which they probably do, sort of typical range of um, protections taken by, say, a private equity investor. Well, if that does enable them to influence the material policy and there are other risk factors present, so for example, in relation to the activities that are being carried on by the target, then whilst you wouldn't have to make a mandatory notification, you might want to think about whether or not you should make a voluntary notification. So those base guidance notes, I think, are helpful. They give a bit of clarity to the regime. And like I say, they highlight the fact that it isn't just straightforward acquisitions of shares that we're talking about. And there are quite a range of scenarios that can be caught by the new regime. And that was highlighted by the next thing that I wanted to mention, which was because we have had our first transaction that has been blocked under the NSI regime. And again, this was this was interesting because it wasn't a typical sort of acquisition. So the proposed transaction here involved the University of Manchester and a company called the Beijing Infinite Vision Technology Company Limited. And that's a Chinese company which uses 3D rendering technologies to create images, images, or animation or virtual reality for various different settings. It says it uses it for residential or cultural and commercial projects. So, like I say, the proposed transaction here wasn't an acquisition of shares, but actually it was a licensing of intellectual property rights. So the university had entered into a license under which the Chinese company was going to be able to use the intellectual property in certain vision sensing technology to develop and sell licensed products. So it wasn't a transaction which required a mandatory notification under the NSI regime. But where an acquirer gains certain rights or control over intellectual property, as was happening in this case, then a voluntary notification can be made. And the reason you might want to do that is because it would avoid the risk of the transaction subsequently being called in for review by BAIS if they decided it was one that they were interested in. So in this case, it looks like that is what happened, that the university took the decision to voluntarily notify the licensing arrangements to BAIS. So BAIS then had to decide what it was going to do. Was it going to clear the transaction to proceed, or was it going to impose conditions on the transaction, or was it going to block the transaction altogether? Now, Bayes says that when it's making that decision, it's going to look at three different risk factors. So those are the target risk, the acquirer risk, and the control risk. So in relation to the target risk, that's about the entity, an asset or asset being acquired. So in this case, obviously that was the technology, um, and whether that is being used or could be used in a way that poses a risk to national security. So that's the target risk. Then we've got the acquirer risk. So that's whether the acquirer, so in this case that was the Chinese company, has characteristics that suggest that there is or might be a risk to national security from it having control over the relevant entity or asset that's the subject of the transaction. And then there's the control risk. So that's whether the amount of control that the acquirer is going to gain from the transaction could pose a risk to national security. So, in its notice of final order, Bayes indicated that in this case, the relevant technology had dual use applications. So, it could be used for both civil and military purposes, and that is one of the 17 sensitive sectors that the government is particularly interested in under the NSI regime. And Bayes has said that the technology that the university was proposing to license to the Chinese company could be used to build defence or technological capabilities which it believed could present a national security risk to the UK. So, because of those concerns, looking at those risk factors, Bayes made an order preventing the licensing of the intellectual property rights from proceeding. So I think that decision is interesting. It highlights, I think, the fact that the government can and indeed in this case will take a much more interventionist approach under the national security and investment regime. It was obviously concerned about the possibility of sensitive technology falling into Chinese hands and being used in a way that could pose a risk to the UK. And like I say, the university obviously took a prudent approach in deciding to make that voluntary notification, which ultimately led to the transaction being blocked. But by doing that, it prevented the transaction being called in for review post completion, under which the government could then, for example, have required the whole thing to be unwound or imposed other conditions on the parties. So that's it in relation to developments in the national security and investment regime. Now let's have a look at developments in relation to restructuring plans. So, restructuring plans were part of the measures that were introduced in response to the COVID-19 pandemic, but they were always intended to be a permanent feature. They weren't just one of the temporary measures to help businesses out during the pandemic. They were intended to be permanent and are indeed still around and will be for the foreseeable future, certainly. And what a restructuring plan does is it allows a company that is in financial difficulties to enter into a compromise with its creditors and or its shareholders. And a key feature and the reason that restructuring plans have got everybody a bit excited was because you are able under a restructuring plan to impose that plan on dissenting creditors. So even if creditors have voted against the plan and they don't want it to go ahead, you can impose it on those dissenting creditors, provided that at least one class of in the money creditors, so one class of creditors that have got an economic interest in the plan, have voted in favour of it, and also provided that the dissenting creditors would be no worse off under the plan than they would be in the relevant alternative. The relevant alternative being whatever the court decides is most likely to happen to the company if the plan isn't imposed. So that could be an administration or a liquidation, whatever, probably some sort of insolvency proceeding, or maybe trying to trade out of that insolvency. So the first restructuring plans that we saw being used after they were introduced tended to be used by some big companies. So key ones were Virgin Atlantic, which obviously was hit very hard by the pandemic, and also Virgin Active, the uh, chain of Virgin gyms. Um, but we're beginning to see that actually uh, they don't have to it doesn't have to be a really big transaction in order to justify using a restructuring plan. We're beginning to see them used more in the SME market. Um, and that was the case in a recent decision in relation to a company called Houst Limited. So this was a company which provided property management services for short-term holiday lets. So obviously, um, perhaps unsurprisingly, the COVID-19 pandemic had a significant adverse effect on its business. People weren't able to go on holiday. So, as a result of that, the company was both cash flow and balance sheet insolvent. And in fact, three of its creditors were threatening to issue winding up petitions. So the company proposed a restructuring plan. And there were various elements to this. Some of the sort of key features were that uh, £500,000 of new money would be invested into the company. So some new preference shares would be issued. The bank's debt of about £2.8 million was going to be reduced to £750,000, and there was a plan for how that would be then repaid. HMRC's debt, which was about £1.8 million, was going to be repaid at the rate of 20p in the pound over 3 years. And then unsecured creditors were going to receive about 5p in the pound over 3 years. So the various class meetings that were then held to approve the plan, 5 of the 6 classes voted in favour, but HMRC voted against it. Now, the judge had a look at the plan and decided that in terms of, well, if the plan wasn't imposed, what would be the relevant alternative? What would be most likely to happen? And it decided that that would be a pre-pack administration sale. And the bank said, sorry, the court said, well, if that happened, the bank would probably only receive about £225,000 as opposed to the 750 it was going to receive under the plan. And in particular, HMRC would likely receive about 15p in the pound for its preferential debt, as opposed to, remember, it was 20p in the pound under the restructuring plan. So, thinking about the two conditions that the court had to be satisfied had been met in order to impose the plan on the dissenting class of creditors. So, had the plan been approved by at least 75% of those voting in a class that would receive a payment under the relevant alternative? Well, yes, it had, because the bank in particular had approved the plan. And then would the dissenting class of creditors, so HMRC, would they be no worse off under the plan than they would be in the relevant alternative? And again, here the court said, well, yes, that's right, because the dividend due to the HMRC under the plan of 20p in the pound is more than they would be likely to receive in the relevant alternative of pre-pack administration, where it's more likely to be 15p in the pound. So in this case, interestingly, although HMRC sort of just objected to the plan, and they seem to be objecting to it just sort of on the basis of principle that they're going to object to all plans, they didn't provide any evidence to challenge the company's valuation evidence regarding the relevant alternative and how much they would be likely to receive. Um, so, in fact, if anything, HMRC appeared to accept the fact that they would be better off under the plan. Um, so the judge exercised the court's discretion here and sanctioned the plan and crammed down HMRC as a dissenting class of creditor. So they imposed the plan on HMRC, even though HMRC didn't want them to do that. So, as I say, it's interesting that we're beginning to see restructuring plans being used in relation to smaller companies than those that first took advantage of it. Um, it does involve a court procedure, so in that sense, perhaps slightly more expensive, but it is going to be, I think, a very useful tool for companies in financial difficulties that are looking to restructure their debts, because provided at least one class of creditor, so your kind of key creditor, maybe your secured creditor, often it's the bank, provided they vote in favour of the plan, then you can't be held to ransom, the company can't be held to ransom by a class of creditors that actually is out of the money, or would be out of the money in the relevant alternative, or at least certainly is going to be treated better or no worse off under the plan than under the relevant alternative. So I mentioned that one of the early restructuring plans involved Virgin Active. And actually, that was the first time that the court used its powers to cram down classes of dissenting creditors. So in that one, there were five classes of landlords, and only one of those classes of landlords approved the restructuring plan. But nonetheless, the court did sanction the plan on the basis, again, that the dissenting landlords would be out of the money and therefore they'd be no worse off in the relevant alternative. But there's a wrinkle come out of that plan with Virgin Active, because the premises that Virgin Active operated out of in Leeds had been assigned, they'd been acquired by Virgin, basically taking an assignment of a lease from an existing tenant. And when that assignment was done, the former tenant guaranteed Virgin's liabilities under the lease to the landlord. So we then have the Virgin Active restructuring plan, where Virgin Active's obligation to pay the rent due under the lease of those Leeds premises was compromised, and the restructuring plan was imposed on the dissenting landlords. So the landlord, unable to recover any rent from Virgin, brought a claim against the guarantor of those liabilities. And that was the recent case. It's called Oceanfield Limited versus Nuffield Wellbeing Limited. So the court now had to decide, okay, well, so what's the impact of the restructuring plan on the guarantor's obligations now that the obligation for Virgin to pay the rent has disappeared? What obligations, if any, is the guarantor left with? And the court had to decide between the landlord's arguments and the guarantor's arguments. So the landlord argued that the restructuring plan rewrote the liability of Virgin Active by operation of law, leaving the liabilities of the guarantor under the lease unaffected. But perhaps unsurprisingly, the guarantor argued that the restructuring plan rewrote the terms of the lease, releasing Virgin Active from its liability to pay the rent. So the amounts that the landlord was now claiming hadn't or would never fall due under the lease, and therefore there was effectively nothing for the guarantor to actually guarantee because there were no payments due. So the court looked at all of that and agreed with the landlord. And the court said that the restructuring plan takes effect by operation of law. It said it's a statutory scheme that, in this case, releases the tenant from liability under the lease by providing that those liabilities are not payable by the tenant. But, crucially, it's only effective between the landlord and the tenant. And the landlord's rights against third parties, such as a guarantor, are unaffected. So although the restructuring plan had released the tenant, Virgin Active, from future liabilities under the lease, it had not also released the guarantor, because the guarantor was not a party to that restructuring plan. So the judge granted summary judgment in favour of the landlord, who was able to pursue the guarantor for those payments. So it was the first time, that case was the first time that the court had directly considered the impact of a restructuring plan on a third party. And it's interesting, I think, to see that even if the primary liabilities have been compromised, then the third party can still find themselves liable in respect of the relevant obligations. So that's it for this episode. I hope you find all of those developments interesting, and I'll see you next time. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.